When we're dividing up assets and debts of a marriage, there's actually two schools of thought in the United States, and those two schools of thought are called an equitable distribution division of property, or something called marital property, if everything is considered marital property, or community property, people really refer to it as. And that depends on what state you're in. As of today, I think it's 42 states that are equitable distribution states, 8 states in the United States that are what we call community property states. So it really depends on what jurisdiction you're in with how we're going to divide up the property and what we're going to recommend. The benefit, and one of the great things about going to mediation, is that we can horse trade the property and we can figure out, okay, what's really important to me? Is the beach house more important than the mountain house? Which one do I want? Maybe one can pick one and one can pick another, and that's what the parties want, and then we can even that out and maybe pull from an account on that. If there's debts, sometimes we're fighting over debts. We went through, in the times that I've been a lawyer and mediator, we went through a couple of really serious problems in the market where all we were doing is dividing up debts. And we can be super creative with that as well, because maybe somebody can write the debt. We can speak to other attorneys, maybe a bankruptcy attorney. We can do things to get low interest payments on debt. We can be super, super creative. If you just go right to litigation, that creativity is gone. The judge has no ability to kind of, somebody said to me once, slice the pie nicely. Basically, the judge is going to take a sledgehammer and the pie's going to go everywhere and people are just picking up little pieces of crushed pie. But when we can slice that pie, when we can really look at everything, we can do something that's fair and works for both of the parties. When it comes to when we have very advanced or some very sophisticated property disputes, sometimes we have trust problems, sometimes we have issues of leveraging or collateralizing property against something in an asset. That's where mediation really hits a home run out of the park, because we really have the power in mediation to not only do full disclosures, but to truly understand what's going on, maybe speak to an accounting or forensic professional, come up with some system or some way that we can be fair to both parties. I'll give another example. Sometimes we have what I refer to as the magic beans. Maybe I have an RSU, or maybe I have a stock that I invested in and one day it will become Apple or Tesla or something. But maybe I don't want to wait, or maybe I can't wait. So do we have people stay along for the rides? Do we have people cash out now? And what value are we going to use? Are there tax implications? Quite frankly, that's where I think we really, really thrive, because that's where we can get the most creative. The first thing we do is get all the information. If we have to reach out to a professional to help us, then we will reach out to a tax expert by way of example. And then we will try to net everything out and figure out a plan that best works for the people. But it really is a better way to do it, because the judge cannot be as surgical in the precision of figuring everything out. And quite frankly, even in litigation, if we do have forensic evaluations and we have all this tax implications and we have all these fancy charts that we've paid sometimes $75,000 or $100,000 to obtain, by the time we're in front of a judge for a trial, it's a year later, and we have to refresh them anyway and spend another $30,000 to $40,000 to refresh this information. Let's just all sit in the room, figure out what it is, how we're going to do it, what do you want to do, here's what we can recommend, and let's get it done. When we're in a mediation setting, or sometimes even in a litigation setting, we have the parties that are fighting over, well, who's going to get the house? What do we do? How do we do it? We both want the house. How are we going to resolve this? So in court, basically, the court's going to order the house sold. Nobody gets the house. And sometimes, unfortunately, people turn litigation into emotional stuff and they say, fine, I want to do that because as long as I'm not getting the house, my spouse shouldn't have the house. That's the very definition of cutting off your nose to spite your face, because oftentimes what we're talking about in that case is maybe we've had to displace kids, displace an elderly parent who might be living in the house. So we really talk through the reasons why one party wants to stay in the house and keep the house. Sometimes that party can't afford to stay in the house, and maybe what we do is we defer equity, as we would say, like, I'll get my half of the house, maybe not now, maybe in 2 years. So what we do is we try to get to the examination of not only what the house is worth now, how much does it cost to maintain the house, who really needs the house, do we need to have somebody in a school district? There's a lot of reasons as to why one person might want the house or stay in the house. Maybe it's a family house, but we have to get to the, first of all, can we afford it question, and second of all, how do we fashion this so that both parties are happy that we have made the right decision when we were in that environment. In litigation, you don't get to make those choices. In litigation, the judge makes those choices. And if there's anybody out there in this universe that thinks the judge is going to do exactly what you want the judge to do because you want it or because you're right and the other side's wrong, you're wrong. The judges will do whatever the judges want to do. If there's any questions that you might have about property division or assets or debts or how we do it, please feel free to take a look at the video library, give us a call, contact us through the website. We're very happy to speak with you.